watching our numbers. So, okay. Hi, everyone. Thank you for joining us today for the Lunch and Learn. I'm Martha White. I'm just the program chair for today, where we're discussing the multifamily child support adjustment, as well as the Hauser case and the impact of the Hauser case on Baltimore County's policies and procedures. Just so everybody knows, if you could please be mindful and mute yourselves. Please keep yourself muted. There's a lot of background noise and we can't mute you automatically without a good bit of work. So if you could please mute yourself, and then if you would please either hold your questions and hope we have time to open things up for Q&A, or put your questions in the chat would be very helpful for us. And with that, I will turn this over to Magistrates McBee and Palius, and I believe Magistrate Palius is going to start. Thank you.
Good afternoon. Thanks for joining us. I think we wanted to start talking about Hauser. Hauser's going to have more of an effect, I think, on how things are done in Baltimore County. The Hauser case didn't change things really, but it changes things in practice in Baltimore County. Maryland case law. We put together a handout, which I think has been distributed. I see
Actually,
something shaking
think
their head no.
Rachel's going to put that in the chat, and she'll.
I'm just waiting for
a link
for a few more people to join. Yep.
Okay. All right. I don't think I need to go through the facts of Hauser at this point. Probably everybody's read Hauser. So I don't think I need to go through the facts of Hauser. So I think everybody at this point has probably read Hauser. But I think Maryland case law has long held that the child's right to child support can't be bargained away or waived. But in practice in Baltimore County, we've held that you had to plead child support, and obviously there's the rule that financial statements had to be filed. So that's how we did things in practice. Now in Anne Arundel County, which is where the case came from, they've long practiced that child support needed to be addressed. And so that's how Judge Wax approached the case. And when counsel there wanted to say that they agreed that they wanted to waive child support, he pressed them on why they were doing that, and they didn't give Judge Wax a good reason, and that was the problem. So the holding was that the parents can't bilaterally waive the issue of child support. So that has led to the reality that other jurisdictions need to change the way they do things. And in Baltimore County, we have adhered to pleading requirements. So if child support wasn't pled, we didn't address it. But in light of Hauser, if just custody is pled, we still need to address child support in light of Hauser. So the implications come up in various scenarios. So Magistrate McBee is going to first talk about uncontested divorces.
All right, good afternoon, everybody. Yeah, so in terms of the uncontested divorce, we can't do the charge generally as part of the divorce itself. If we have a situation where parties are suggesting that it's a charge generally matter, frankly, the magistrates are trying to get the information to perhaps run some guidelines so that the divorce can be done in full. However, I had a case today on my uncontested dockets where the parties wanted to be charged generally. They had it in a separation agreement and were not willing to provide financial information for me to calculate child support. In those kind of cases, what we're doing is we're still granting the divorce. We are kicking the issue of child support, depending on how long, as the magistrate thinks it would take. Any cases of 30 minutes or less are going to be referred to Magistrate Farmer for a child support hearing. Anything beyond that, if it's a more complicated case, somebody who's self-employed, things of that nature, that we believe it's going to take longer than a half hour to resolve, the child support hearing will be with one of our other magistrates, myself or anybody else. And this has, in terms of the uncontested, obviously you need to establish child support because at some point in time, maybe you're going to have a modification case down the road. And if you haven't established what the guidelines were at the time of the divorce, then that may create some difficulty to show a material change in circumstances down the road. So we are, and sort of to follow up with what Dilip said, for the longest, this Hauser case did not change the law at all. For the longest period of time, I'm old enough to have given clients advice all the time. We cannot not deal with the issue of child support. It's got to be dealt with. I think either at the pandemic era or for other reasons, we've gotten away from that, and that's got to come to an end. Child support absolutely has to be dealt with. And in uncontested divorces, that's how we're dealing with it. We're granting the divorce. We're kicking a determination of child support to a child support hearing, either heard by Magistrate Farmer or one of the other magistrates. Go ahead, Dave.
Just to add on to that, you can still do a general charge. There can still be a deviation, but you have to provide reasons why a magistrate or judge can make that finding to deviate. What are the separate costs that are being paid by each parent that will allow the fact finder to deviate? That's what has to be provided, and that's what didn't happen in the Hauser case. And
Right.
if you read the case, Judge Wax pressed the attorneys on what were the separate costs being paid, and counsel kept relying on constitutional arguments that were unavailing, and that was the problem in the case. Had they provided those costs, I think Judge Wax might have deviated. The child support, I think, amount was $2,105, and they wanted it to be zero, which was a significant amount to deviate. They didn't give them any reason to deviate. And that was the problem in the Hauser case.
And that's another example, I think, of a case where we're going to kick it to a magistrate to conduct a child support hearing. Because typically on the uncontesteds, we don't have lawyers, or the lawyers perhaps are not prepared to discuss child support, thinking they didn't have to, and we're not prepared to discuss any form of deviation. So those are cases that are going to end up having a child support hearing with one of the magistrates.
So the other area this comes up with is scheduling conferences in which only custody is raised, and that would be the first opportunity in which a magistrate could bring up the fact that child support is going to be at issue. Magistrate McBee, do you want to talk about scheduling conferences?
Sure. So as all of you who've done scheduling conferences with any of us, if we do not see in your pleadings in the file that a financial statement has been filed or is in the court form, we're advising each party that they must file under 9203, must file the financial statement. That's not only true in child support cases, we also end up having to advise people in alimony cases that they have to file the long form financial statement. So what we do is, if it's unrepresented people, we are giving them the ability through online availability of the financial statement, short form or long form as the case may be. And we advise them at the scheduling conference, even if they haven't mentioned child support as being an issue, but custody is an issue, we're telling them child support's an issue now. And you have to file financial statements, and you have to be prepared at the time of your hearing to put on evidence regarding child support.
It's implicated in visitation cases, and it's implicated in third-party de facto cases, but not just third-party cases that are exceptional circumstances or fitness of the parent cases. So it has to be a third-party de facto case where the third-party plaintiff has more than 92 overnights.
And just to piggyback on what Magistrate Palo said, if it's a case where you're modifying access, obviously, if the access doesn't change the nature of custody, it still remains primary to one parent or another. You're not obviously in those circumstances having to address the issue of child support.
So next is default hearings. We see that a lot. We see default hearings where only custody is requested, and then both parties sometimes appear. One party may appear, and then we as magistrates have to tell the parties the court has to address child support. So the court may be able to address child support then, or the court, like in an uncontested hearing, may reset the case for child support to be addressed. The issue is notice. The magistrate or judge may make a determination that the other party doesn't have sufficient notice. So that will be determined by the court, whether there's been sufficient notice and due process. We talked about visitation, touched a little bit about visitation cases. The issue with visitation is whether that 92 overnights has been implicated, whether it's 92 overnights or more. That's when child support would need to be addressed. Sometimes parties will just file a complaint for visitation. If it changes it to or implicates 92 overnights, then the court will then need to address child support. Pendente lite or interim hearings, it's the court's discretion as to whether it would need to address child support at that hearing or whether it can be pushed to the final hearing. All right, I think that's pretty much it for Hauser. Multifamily adjustment.
Okay. All right. So as you all probably know by now, the code has been changed as of October 1. Family Law Section 12201C2 deals with the multifamily adjustment. So when is it available? When does it kick in? The parent who may be the obligor owes a duty of support to a child living in the parent's home. Has to be living in the parent's home for at least 92 overnights. Additionally, that you don't use the multifamily adjustment if that parent is already under an order of support, because obviously that's already in the guidelines. So to determine the multifamily adjustment, the first step after you've had testimony that there is a child living in the obligor's parents' home and that it's more than 92 days, that you go to the schedules in 12204C, and you find the basic obligation. I've provided a example. So if you had a parent who's making $4,800 a month, has 2 children living with him or her for at least 92 overnights, in which that parent owes a duty of support, not a court order, and you multiply that, the duty of support from the guidelines, by 75%. If you go on and you look at 1204, that will give you what the multifamily adjustment is. Now, here's the good news for everybody. Sassy Calc has it in there. You don't have to do the math. All you have to do is plug in the numbers, and the adjustment will be done for you. So do you always have to do the multifamily adjustment? The answer is no, it's not mandatory. It's within the discretion of the trier of fact. If you find, as the trier of fact, that the use of that adjustment would lead to an unjust or inappropriate result, then the magistrate or judge can decide not to apply that adjustment. If the magistrate or judge feels like the application of that adjustment would be unjust or inappropriate, but feels that some adjustment needs to be made, that magistrate or judge can deviate from the adjustment itself and give some credit. It's all going to be fact finding, right? If you're going to have a case where the multifamily is going to be something that could be considered, you have to make sure that you produce the evidence that the children are living at the obligor's home for 92 overnights. You have to have documents with respect to whether or not the application of that adjustment is appropriate. And obviously, it's for a child that they have a duty of support. They don't have a duty of support for a step parent, for a stepchild. They don't have a duty of support if you have a child who's over the age of 18. So, you know, it's got to be for a child that they are going to have a duty of support for. As I said, the Sassy Calc does the math for you. And that's essentially the multi-family adjustment. I have sent, and Rachel has, about 4 or 5 pages of examples of how it works. And it also is sort of fun. It deals with Betty and Wilma and Fred and Barney. I can take a couple minutes to go over how it works. So you'll get this document, but if you want to just listen to this. After 10 years of marriage, Fred Flintstone confesses to his wife Wilma that he's been having an affair with her best friend Betty, and that he is actually Bam Bam's biological father. Wilma kicks Fred out, and Fred starts living with Betty and Barney. The case comes for divorce, and Wilma asks for child support for their child. Parties agree that Pebble should primarily live with Wilma, and Fred should have some overnights. Parties can't agree on the amount of child support. At trial, Wilma testifies she earns $2,500 a month, and Fred earns or had earned $5,500 a month. He lost his job. Now he's only making $1,400 a month. Betty testifies that she and Barney are helping him out. The court grants divorce, and and also grants physical custody to Wilma, and Fred has weekend visits. Spousal support is not awarded. Does the multifamily adjustment come into play? Yes, as a de facto parent, which Fred would be, has a duty of support to Bam Bam. During the proceeding, the court did not order Fred to pay child support for Bam Bam. And Fred lives with Bam Bam for obviously more than 92 overnights, and that kicks in the multifamily adjustment. You can look at, there are examples of how it works. And the handouts that I provided have those in there. So that is the multifamily adjustment.
Okay.
We wanna-
I'm sorry, I didn't mean to interrupt you.
No, that's okay.
I know we had one question about whether or not a person that is receiving, receiving child support for a child, they have primary custody of that child. Do they get a multifamily adjustment in the child support obligation for child number 2?
So they're getting support from another person,
Right, for child number 1.
right? And that child obviously lives with them. And then the question is whether or not they get the adjustment.
Right, so they have custody of child number 1, but they do not have custody of child number 2. And so they would be the obligor for child number 2. But they're the recipient for child number 1. And so do they get a multifamily adjustment for child number 1?
Child number 1. You mean for child number 2? Or
Oh, I'm sorry. I do mean in the calculation for child number 2, do they get the multifamily adjustment with respect to child number 1, whom they're receiving support for?
that's a very good question.
Yeah, my initial thought is no, because they're receiving child support for the first child. I mean, the purpose of the multifamily adjustment is that you're supporting that child that's in your home, and that's what the adjustment is for. It's because you're supporting the child that's in your home, that is not a child of the parties that are before you. It's for the court to account for the fact that you're supporting another child that's not before you. That's my thinking about it.
And my thought was, even if a person is receiving child support for a child, they're still contributing to that child support as well. So that was why I was wondering, obviously if they're the payor of the support, they get the credit. But if they're the recipient, they still have.
If you're looking right at the statute, you're probably right. Sort of an unusual set of facts, but I guess so, because the statute talks about the child living with that parent for 92 overnights, which presumably they would be. They do have a duty of support that goes over and above whatever they receive. And they're not under a separate order of child support for the child number 2. So, yeah, I think it would apply. If you just go straight down the statute.
Okay. So let's see, Alyssa Halloran has her hand up.
Yes, I had a question about retroactivity. We have one of these cases where someone has filed for custody, didn't file for child support, and then we're getting to the point where we're determining child support. Ordinarily, we would have the potential to ask for retroactivity back to the date of filing, but there was no filing in this case, right? I guess that could happen. So Is there no retroactivity in that case, or is there an assumption that a custody filing triggers retroactivity in and of itself, even if it wasn't pled?
I would think that if it wasn't pled and asked for in terms of retroactivity, I'd have a difficult time granting retroactivity.
I think it's the same issue of notice and due process.
Yep. Because actually you're having competing things, right? You're having notice pleading versus Hauser. Theoretically, under notice pleading, if child support wasn't pled, are you under notice? And that's why we are giving everybody an opportunity to have a child support hearing.
Thank you.
Sure.
Can I suggest something?
Sure.
The statute that provides for that makes retroactive child support to the date of filing mandatory specifically refers to if it's a pleading in which pandemic date support has been requested.
Right. So if it's not requested,
Mm. I see Miss Amy Vora has her hand up.
Yeah, hi, everybody. I'm Ami Vora from Maryland Legal Aid. I just wanted to provide some, I don't know if it's legislative context, but some policy context for the earlier question, Martha, that you had about whether, let's say, a custodial parent who has a child in their home that's not subject to the instant case, but for whom that CP was already getting child support, whether that person would get the multifamily adjustment credit. And you're absolutely right that the way that the statute was contemplated, you would get that credit. The CP would get that credit. I was part of the committee put forward by the Child Support Agency's like Guidelines Commission, and I was able to sit in on the discussion about the creation of the bill for the multifamily adjustment. And that question was raised, is it double dipping if somebody's getting child support for somebody and then also wants to claim sort of a multifamily adjustment credit for them in the guideline calculation for a separate child? And the committee determined no, for the exact reason that you suggested, Martha, which is that custodial parent has their own duty to support that other child. And yes, they're receiving child support, but that's because that's the other NCP's duty to pay. So they still need to have their contributions to that child be accounted for. So just wanted to plus one your comment there that that's how the statute was intended to be applied.
May I
Thank
ask a question based off of that?
Sure.
Should that not also apply if you have a parent who is paying child support when they get the credit for that payment as a child support obligation, but then they also have 92 overnights and they have a separate duty to support that child when that child is in their home? Does that make sense?
so
Should
what
they
you're
not
saying
be
is
able to double
they
dip?
have a child support order that they're paying?
Correct. But they also have shared custody. So they are paying. I've got a case where I have both of these happening in Anne Arundel County, but they are paying child support,
Mhm.
but they have those children also in their home for over 92 overnight. So they are paying, they have a duty to support those children when they are in their home.
I might be wrong, but I think with respect to if they're under a support order,
Correct.
I don't think that would kick in the multi adjustment, because if you look at the statute, it specifically says that.
Okay. Thank you.
Yep.
We had a couple questions in the chat, one being if a child support modification was filed prior to October 1st, but has not yet gone to trial, can the multifamily adjustment still be applied at the hearing?
It's effective October 1st.
Yeah, I don't think it's effective before that. Now,
I
It's
mean,
not,
would-
it's not based on the filing deadline. It's
okay.
it's effective now.
And then Kathleen Walber had asked, in an instance where custody changes from sole parent A to sole parent B, and the parents agreed to end support to parent A and establish a general charge for parent B with no review of the worksheet, does it follow that a motion to modify the moving party would not need to show a material change in circumstance since there was no review of the general charge. Well, hopefully that shouldn't happen anymore, right?
I would hope not.
Uh,
So I'm not sure I even understand the question, frankly. So what Catherine's saying is that as a result of filing, the one parent now has custody where they didn't?
Yeah,
That's
I can clarify, correct. I mean,
Okay.
the child changes from mother to father because of an
Right.
emergency. There's just a general charge that both parents agreed to, and now father wants to modify to have child support.
It's gonna be really hard.
But does he have to show a material change? And because there was no review of the worksheet, because it was a general charge and the court just agreed to it on consent order. So
Well, I don't think that means that you can't have a material change in circumstances. I don't think if you can show what the income was and have testimony to say what the parties were sharing at the time of the general charge and what the situation is now, I think you could probably show it. I don't think it'd be easy, but I think the answer is yes. Did I answer your question, Catherine?
it does, thanks.
Okay.
Anybody else have any questions?
It looks like there's 6 in the chat, Martha.
Oh, there are, sorry.
Looks that way.
Mhm. I don't see any, maybe you got
Okay.
direct
I have a
questions.
I have a question.
Go
Actually,
ahead.
this is about the Hauser case. And this may be obvious to others, but not to me. So if you have an above guidelines case, my understanding is there is a rebuttable presumption that the minimum amount of child support would be the maximum amount in the standard child support guidelines. That's to begin. I think everybody agrees on that part. Am I right? There's more to the question.
All right, go ahead.
So in order to compute that minimum amount, you would have to, let's say, father has 75% of the total income and mother has 25% of the total income. You would have to apply those percentages to the 360,000 maximum in the child support guidelines to come up with what would be the amount of child support at the maximum, which would be the minimum for the above guidelines case. Does that make sense?
So then you have to go beyond that.
Then you have to decide whether you can deviate downward from then, and you'd have to provide specific evidence why you should be paying less than the maximum of the child support guidelines. Is that,
Well, I think you're always going to have to, if you're seeking to deviate, whether it's an above guideline case or a regular guideline case, if you want to deviate, you have to produce the evidence to make it appear that that deviation's in the best interest of the child or children.
but I don't, but my question, I guess, is that you don't have to show that you're deviating from the extrapolated guidelines. What you have to show is that you're deviating from the rebuttable presumption of what would be the minimum amount of child support. So maybe it's not as easy as I thought.
No, it's not. Would you have, well, let me ask you this, Carol. So if it was above the guidelines and would you then have to determine what the appropriate child support would be above the guidelines, either by extrapolating that out or using other means to do so, and then drop back to deviate? Is that what you're saying?
So I've always sort of been confused about whether there's any kind of presumption that the extrapolated guidelines would be something you'd start with, even though most people use them. I mean, it's supposed to be needs-based, and at that point, I think when you get above the guidelines, but they do clearly say there's a rebuttable presumption that the minimum amount is the maximum on the limited child support guidelines. So So let's just stick with my original question. If you wanted to pay less than the minimum amount that's required, the rebuttable presumption, which is the maximum in the child support guidelines, then you would have to provide more specific information about things you're paying to deviate downward from that.
I would think so.
Hauser was an above the guidelines case. And what Wax did was he just took the guidelines, and the guidelines was $2,100 to $5. And he said, why shouldn't you be paying the guidelines amount? And he didn't get a sufficient answer. He didn't get an adequate answer from counsel.
That was the extrapolated guidelines?
I read it as that was the guidelines amount.
So,
I didn't
but-
see that he extrapolated. But I could be reading the case wrong. I thought
Yeah,
that
it doesn't make it clear to me.
I thought that was the guidelines amount.
But I would think, Carol, that you would absolutely have to put forth additional evidence as to what is being paid so that you could deviate down for each parent.
I agree with that.
Yeah.
It's just where am I convincing to deviate from is what I'm trying to figure out. That minimum amount or the extrapolated guidelines amount or
I think that would be hard if the parties are well above the 360. And whether you extrapolate or do some kind of needs-based calculation. I think you have to go from my opinion, or whatever it's worth. I think you have to go from that point, not just the 360 as a ground level or of support for these people. I think you have to go either by way of extrapolation or needs, and then drop back from there. That's what I think. I could be wrong.
and there's no additional requirement that you give more special reasons to go below the minimum.
I don't think so. I think whatever is relevant in terms of what each parent is contributing, or that, let's say the obligor parent is contributing for the benefit of the child or children. I think there's nothing that I'm aware of that says that you have to do special, but I think you have to present enough evidence to warrant a deviation. I don't know that there's a specific point to go to. I just think that's what you're going to have to do.
I see Virginia Yeoman has her hand up. If we're done with that question.
Thank you. I have a Hauser question. In the past, in an uncontested divorce, if the guidelines called for a very small amount of child support, like $50 a month, and the parties wanted to do a general charge, I feel like the court was pretty lenient about accepting that without.
I think something like that, what you're talking about, Virginia,
Yeah,
I don't think we would have a problem with that.
Okay, so that's still
No.
maybe the practice.
Yeah, I think so. I think, you got to look at it somewhat practically. I had a case a couple weeks ago where the child support was, believe it or not, like $463, but mom, who was the obligor, this kid was a big time football player, and she was ponying up about $400 a month. Even the other side testified about that for the child, and you look at it, there was still maybe about $60 that was unaccounted for. I went with the charge generally at that point.
Okay.
I think you got to be practical.
Anybody else have any more questions? I don't see any more in the chat. I'm not sure if.
I don't see any more. No.
I have a quick question. In terms of the evidence you're looking for in order to prove that a child is actually in a party's custody for more than 92 days for the purposes of obtaining the multifamily adjustment credit. I guess what I'm wondering is, like, are you looking for formal custody orders or any other type of additional proof beyond testimony? We've heard some examples in other jurisdictions that Maryland Legal Aid practices in, that some courts are accepting testimony, and that's enough to say, I have an additional child living with me. And other places might be looking for more documentary evidence. So
Well, I would think testimony, you're always going to, as a trier of fact, whether you're a magistrate or a judge, you're judging the credibility of what people tell you. But I think over and above that, for instance, if the child is living with dad to the point where the child might be attending school in dad's jurisdiction, right? That might be a pretty good piece of evidence to have that would corroborate whatever dad's testimony or mom's testimony is. So I would think that would be something. Obviously, the more documents you can get, the better. But a lot of times I'm guessing it's going to be testimonial.
And funny enough, that was the exact question presented in the chat at the same time from Sherry
What?
Boydress. So you guys are synced up with your questions.
Could I ask one more question?
No, of course.
Thank you. And this might be a stupid question because I'm reading it and it's not making sense to me. So I apologize if it is just that. You were explaining that the implications of Hauser is that for visitation cases, it reads here, unless there is visitation access to 92 overnights or more, child support does not need to be addressed. But that confuses me. If I have a parent that's looking for every other weekend, they're going to have 52 overnights a year. Are we not addressing child support? Or am I just not reading this?
No, I think that was what we're talking about, visitation case, I think in terms of not an initial finding, but a modification finding, that if somebody, so let's say that your client has every other weekend and you file a modification, and that modification leads to now that person having 92 overnights or more.
Yep.
So under those circumstances, clearly you're going to have to address child support, right? But if your client is only getting a little bit more access and he or she is still under the 92 and there's really no change, that's what we're talking about.
That makes sense. If you have a client that the modification moves them, they had shared custody, right?
Gotcha.
And it moves the other direction. I guess anytime we're moving from a shared guideline to a sole guideline, it's going to trigger child support.
Yeah,
Am I right?
if you're going to change the where this kid's living or children's living, you're obviously going to have to deal with the issue of child support.
Okay, thank you for that clarification.
You're welcome.
Any other questions from anybody?
Now there's another in the chat, but this may be, you already got to it, Martha, probably.
Okay. Just
Yeah.
think
I think, let me go down here. It was,
the evidence you're looking for.
yeah,
Yeah.
yep.
Okay. No more questions. Okay.
Well, can I add one
Yeah.
more thing? It was just in the back of my head. So when you all look at the handout I gave you on the multifamily adjustment, there's an interesting part to it, I think, anyhow. If you look at the statute, it talks about the parent who's seeking the adjustment, what their actual income is for that. That's different than if you have a situation where you're using I don't want to say this.
Talking about the impute.
Potential income or something like that. If it's potential income and not actual income, you don't use that number for the adjustment. You only use the person's actual income.
Meaning if there's any type of imputed income, we're not making any adjustments.
You can make an adjustment, but let's say under the example in the handout,
Mhm,
Fred's making 14, but he could make 55. And
mhm.
so for when Wilma gets child support from him, that particular case, they use his imputed income, fine. But for the multifamily adjustment, you don't use his imputed income, you use his actual income. So instead of
Okay.
5,500, you're using 1,400.
Okay,
And that's how the statute, it's weird, that's how the statute's written.
yeah. Thank you for pointing that out. Interesting.
So I meant to say that, I forgot. I'm sorry.
Okay, so, just ask to resend the link. Okay. Any other questions or points people would like to make? Okay, hearing absolutely nothing. I think we have finished. Thank you so much, Magistrate. Wait, how would it work to calculate different incomes? How would it work to
Not
calculate?
sure I understand the, following up on my comment, how would it work to calculate? How would what work?
Oops, I think you just, there you go.
So what you indicated was if it's, you're not gonna use the imputed income, you're gonna use the actual income.
Correct.
How,
So the
so,
adjustment. For the
correct,
adjustment.
but how do you do that in the Sassy calc? Because to have the two different incomes.
No. You're only
Okay.
using the actual income for the multifamily adjustment. So under the example that's in the handout that I don't know if everybody's gotten them yet. In that example, Fred had imputed income of 5,500 that Wilma used for their case. Okay, but for the actual adjustment, the way the statute's written, it says the actual income. So in that example, Fred's actual income was $1,400. That's the number you use.
Hi. Any other questions? Follow up based on that? Leon
Are
is
you
waving his
waving,
hand.
Leon, or do you have a question? You're
Question.
muted.
Does Sassy Calc, when they make the adjustment, is there a way of having them factor in the, if you're using the potential income to calculate the support, but you want to use the actual income to calculate the adjustment, does Sassy Calc make that distinction?
Well, I think what we're talking about are like two different things. But yes, I would think that it's a good question, Leon. I think that clearly Sassy Calc does use the $1,400 number. If you're just using imputed income, I don't think you can actually use the adjustment. The way the statute's written, it's got to be his actual income.
Yeah, but okay, maybe because I haven't done this before on Sassy Calc, but it seems like if you're calculating the actual child support obligation first, then you're using the imputed income figure, but then you want to make the adjustment, the arguable adjustment, in which
What they're
case you would
saying-
only, you
I'm
know,
sorry.
you
Go
know,
ahead. Yeah, I interrupted.
how do you then change the
So if you're using for let's say Fred's income, the imputed income, you can't use the adjustment doesn't apply.
are you saying, now if there's imputed income, there's not the multifamily adjustment
If you
wouldn't?
look at the statute,
Okay.
yeah, I mean, I think that's what it says.
Okay, not to use the actual, not to make the adjustment based on the actual income, but just don't make an adjustment at all.
See, I would have assumed that you would just make the mechanical adjustment outside of SASSY You compute the income, the child support based on the imputed income, and then you make a mechanical adjustment. Since SASSY isn't the only way of calculating this,
No, I understand.
you know, maybe they just didn't create an option to differentiate between the two incomes. But I would think that that doesn't necessarily mean that you can't make the adjustment using the actual income, albeit it'll be a smaller figure.
It's gonna be next to nothing.
Well,
Right.
maybe.
Yeah.
I just opened up Sassy Calc to try to see what I could do manually. It does look like you can just manually put in the amount for the multifamily adjustment, but it tells me I need to edit the footnote because I'm manually putting in a figure for the multifamily adjustment.
If you're
Very good.
also using for Fred's income, the imputed income? 'Cause
Yeah,
think
I
that-
can
that's what
manually.
Leon's question was about.
Yeah, it looks like you can do it. That Sassy Calc will let you manually put in a different figure for the multifamily adjustment. It just wants you to reference that in a footnote. Why you've done that.
So got a thing from Sue Parks, says that Sassy Calc does allow you to override and put in an amount so you can use the actual income.
There, yeah.
Thank you, Suze.
Yeah, thanks, Susan. Okay, so I ask again if there's any more questions. And any other questions from anybody? No. Okay, thank you so much for everyone for attending, but thank you absolutely very much to Magistrates McBee, Magistrate Paley. This has been very, very helpful and obviously of much interest since we've had so many attendees and such a lively question and answer period as well. So thank you very much. I hope everybody has a wonderful day. Thank you for coming and participating in this.
Do more of these, Martha. Do more. Thank you.
Thank you.
Bye
Bye-bye.
now.